The following is an independently produced community access program. The viewpoints expressed are those of the community access producer and do not reflect those of Shaw Cable Systems. The program is presented in response to CRTC policy guidelines regulating community programming.
Welcome to Island Justice with Roger Batchelor. Today in the show we've got Barclay Johnson, who's the person who started up the Victorian Legal Clinic. And we're going to be talking about access to justice. So Barclay, I just wanted to talk to you a little bit about your background, and if you could tell us, I know you're a lawyer obviously, and I know you practiced in Alberta before coming here, but maybe you could tell us a little bit about how you ended up in Victoria.
Well, I got my law degree from the University of Alberta in 1975, called to the bar there in 1976. I articled to a fairly good, well-known criminal lawyer, Buzz McClung, who ended up in district court and then went to the Court of Appeal ultimately. I was a little bit disconnected after that from the criminal law. I ended up doing more of a general practice, and that led me into doing some innovative things in Edmonton. I started up two legal clinics inside the downtown Bay store and the Southgate Bay store. And so we staffed that, kept the regular hours, had our prices on the window, and so that people knew what to expect. And everything was going tickety-boo until I realized that was the first year that in the history of the Hudson's Bay that they had a loss, and it was a big loss. So they started cutting back, and we lost interest in the Bay because basically Toronto was trying to establish the lease rates, and it was an experiment that was worth trying. Then we moved across the street, and I typically had a storefront legal clinic there. We had a total of 4 lawyers and 12 support staff, and it was very rewarding. After that, I decided to come to Victoria in 2000. I had a little bit of a break, took off some time, and went to Asia, did some things over there. You're always a lawyer, though. You can never really get away from it. And so I came back, and most recently, I decided this last year to get back on the street again. And so we started a legal clinic at 810 Courtney, right across from the courthouse, at a fairly decent rent. I think anybody that's been around Victoria has seen the white bunker at 810 Courtney. And we've decided to make a commitment to trying to represent unrepresented people at the courthouse. My main concern is that people often don't have enough money to pay for a lawyer, and in some cases are refused legal aid because there's a possibility of them not going to jail, for example. And there are a lot of people that don't feel that they have the money to pay for legal counsel. And I think that's a perception that needs to be addressed. I think people need to understand that lawyers are creative, that we can deliver legal services, but I think that people sometimes need a nudge. You've got to be where people are. You can't be in the yellow pages advertising this kind of thing. It's an expensive proposition. And I think to deliver reasonable services at a low cost, you have to keep control of your costs.
Now I'm noticing your red badge. It says Victorian Legal Clinic.
Victorian Legal Clinic.
But I know there's a little bit of history about your red badge, and I'm going to prompt you to tell us a little bit about the red badge in the courthouse.
Well, unfortunately, a lot of things I do are kind of a lightning rod. When you do anything that results in change, you're going to be upsetting the status quo. A lot of lawyers are pretty conservative, although you see lawyers appearing in court with earrings and multicolored suits and raincoats and what have you. It's a question of taste, I think, more than anything. But I started wearing the name badge in the hallways, and I really ruffled a lot of feathers. People think, some lawyers feel that it's the utmost in bad taste to do that. I look at it completely differently. I just say, if doctors and nurses and dentists can wear them, why not lawyers? Why not go into the courthouse and identify yourself, show that you're approachable, that people don't have to fear walking up to you. I think the major concern was that I was trying to fulfill a role which is already being done by duty counsel. Now, duty counsel is appointed by legal aid, and they're there to, lawyers are hired to do that for a week usually, and they're there to help anybody with legal problems, but there's a limit to what they can do. They're not supposed to form solicitor-client relations. They're there to help people that day, usually not pass out business cards, for example. It's not an opportunity for, I suppose, advertising or trying to get clients. So my approach is that if I go over to the courthouse and people see me wearing this red name badge, I hope that I'm welcoming them to come up to me to get some basic information. I do hand out pamphlets, and I happen to have one here. So we usually give people just a general pamphlet on how the court system works, the role of Crown prosecutor, the role of justices of the peace and judges, and why lawyers are a necessary part of that whole system. And I think that the major complaints that I have about the system is that if people are unrepresented, not only creates problems for everybody else in the system, the judges, for example, and prosecutors have to go out of their way to explain things, and a lot of people are not familiar with procedure, and I think it's a clog on the system as well. So if people can get counsel, I think it really helps the administration of justice. The bigger concern that I have is access to justice. You know, our Chief Justice of the Supreme Court, McLaughlin, states just about every time that she gives an interview to the press that lawyers have priced themselves out of the market, that a large section of the middle class are unable to afford legal counsel. And I've always been a believer in one principle, and that is that if I had to change places with my client and sit on the other side of that desk, could I afford the fees that I've just quoted? And that's my test.
So you talk about access to justice in the same breath that you talk about the Victorian Legal Clinic. So how do you see that clinic fitting into the access to justice that you talk about?
Well, I think getting a lawyer can be a hit or miss thing with a lot of people. I'm not a big believer in letting your fingers do the walking through the yellow pages to get legal counsel, although there's certainly good lawyers in the book. But if you're faced with 30 pages in a place like Victoria and you have to wade through that, and if that's the only way that you can get a lawyer, then I think you're going to find that to be a very difficult or challenging thing. A lot of people do it through referral, word of mouth, of course. Being a lawyer, you know that a lot of your clients refer people to you, and you could probably keep busy without an awful lot of advertising. But for first-timers, people that have just had a problem, and generally what we do is we focus more on the criminal side of things. I'll give you an example, for example, Roger. This is where access to justice is needed. And it's something that I noticed when I started practicing here in Victoria. There seemed to be a greater number of people who were charged with domestic assaults, for example. And domestic assaults can be very serious. They, as you know, can lead to murders, and I think the statistics show that people who do commit murders know their victims, possibly even live with them. But for the vast majority of cases that involve police, where 911 is called, for example, they come out, generally speaking, in the past, when I was a younger lawyer, the police officers had far more discretion, and they would put the parties in their neutral corners and say, look, I think you should leave the house for the evening, go to your relatives, and I think you better look at some counseling issues if that's what's needed. That's taken away now, and generally speaking, what happens is that when you call 911, I mean, the standing joke, unfortunately, is that if you want a divorce in Victoria, you call 911. And by that I mean what happens is that the court system separates the parties. There's generally 90% of the cases, as you know, the husband is led away, and as a term of release they have to sign a recognizance, and that recognizance has conditions to it. Two of the ones that I don't like are no contact with the spouse and no communication.
Direct or indirect.
Direct or indirect. And that may serve to separate the parties and have them go to their neutral corners, but unfortunately that extends over many months unless there's a variation application made, and that's tough when you can't talk to your spouse about it. And I think that the emphasis should be on the family. It should be on helping people resolve their marital issues through counseling, for example, anger management if that's necessary, also family counseling. But if you've got couples counseling as a means of dealing with disputes, how can that happen if you've got a no-go, no-contact order? And I think a good marriage probably would not survive 6 months of no communication. And where you've got people who are in conflict and in a low-risk situation, that may push the marriage into a divorce. And that's unfortunate, because I think there are terrible consequences in society for divorce, raising of children, and especially. And I think that I'd like to see some changes as a result.
But relate this back to the access to justice piece and trying to figure out how that fits in.
Well, I think that people who are in that position, as an example, need to talk to a lawyer, find out what their options are, to guide them through that system. They're usually lost. Quite often it's a first encounter. In a lot of cases people don't have the money, or they have a perception that they aren't going to be able to have enough money for counsel, and they struggle with that. And I think that that's a typical example where they do not get access to justice. In fact, everything is kind of stacked against them. It's a stacked deck. And lawyers are needed in those situations to create a proper balance in the judicial system. Of course, from that situation and other situations where you do have these recognizance issues, as you know, up to a third of the daily court lists here in Victoria can be for breach of probation or breach of conditions on a recognizance. Again, people need help in those situations. And because the consequences are that you're criminalizing that behavior, people can lose their jobs over that or not get a job. And so the consequences are dire in some cases. People do need counsel. They do need people who are willing to at least give them some advice. In our clinic we offer half an hour of free advice. We tell them what the situation calls for generally. In some cases we go a bit further than that. We will contact the prosecutor to see whether, for example, they might consider a peace bond instead of criminal charges. And so we try our best to have an open door policy. Ultimately, what I'd like to see, if it's possible, is to have the clinic as an open referral system, so that people who want to do that kind of work, and I'm speaking of lawyers, can simply contact our office, and we would refer people out, and then there would be a fee arrangement with transparency to the client, no extra fees. So we're actually getting lawyers to work for agreed fees.
Okay. We're just going to take a short break. We'll be back with Island Justice with Roger Batchelor.
You're watching an independently produced community access program. The viewpoints expressed are those of the community access producer and do not reflect those of Shaw Cable Systems. The program is presented in response to CRTC policy guidelines regulating community programming.
Welcome back to Island Justice with Roger Batchelor. Today we've got Barclay Johnson from the Victorian Legal Clinic, a clinic that he started, and we're talking about access to justice. And the next question I wanted to ask you about, Barclay, was I think you initially spoke a little bit about some of the changes to the legal aid system that's sparked a difference in the way people can access justice, especially in criminal and family law. Can you talk a little bit more about what some of the changes that have led to people not being able to get legal aid?
Sure. I think there's got to be some balance in my view. I don't want to be rabid about taking this down one opinion road. I've thought about this quite a bit, Roger. It's easy to say that the system's broken because there's not enough money to fund legal aid. You know, you can't run legal aid without adequate funding. I've found that wherever there's a lack of money, or if there are cutbacks, there's always hard choices to make. And you have to decide the types of cases that people are going to get legal aid referrals for and those that you don't. Now, one of the ones that bothers me is that, and there's two aspects to this, that legal aid generally has an income ceiling of $1,425. That's the magic number. If you're above that, for financial reasons, you're deemed to be able to look after your own affairs and get your lawyer and pay out of that. Of course, that's a low threshold. A lot of people in this city, given the high cost of living here, would have a hard time if they're just $1,500 or $1,600 if they're over. So you can get disqualified from having legal aid on that ground alone. But if you do come under that ceiling of $1,425, you can still be refused legal aid if it looks as though you're not going to go to jail. Well, how do they determine that? Well, the Crown Counsel, as part of their disclosure package, has a little yellow form on it, and they have the Crown's initial sentencing position. And they have a number of boxes, one of which is jail. And if they tick off jail, then that meets the second hurdle for the applicant.
Right.
The problem with that is I don't believe that legal aid should be delegating that decision to Crown Counsel. Crown Counsels shouldn't be a determinative factor in whether somebody qualifies for legal aid or not, for a number of reasons. I think that if somebody's interested in getting a guilty plea and they're not represented, it's much easier to deal with somebody on that basis. Maybe some prosecutors would disagree with me on that point, but I think the real problem with that is that there are a lot of very poor people that can't get lawyers.
Right.
They're really poor. If they're not going to go to jail, according to the prosecutor, they're not going to get counsel. The problem again with that is that very poor people tend to have a lot of brushes with the law, as you know, and they become recidivists. That's shoplifting that goes on. At some point, they're going to get whacked. Somebody's had enough, and then there's going to be an ISP that says jail. Well, at that point, I think it's too late to have legal aid step in and say, well, you need a lawyer now. Well, you've now got a criminal record, and maybe some of those cases could have been disposed of by diversion or some other method, and maybe the criminal record wouldn't be there. The whole idea is to try and make sure that people through the criminal justice system understand what's right and wrong, and that they can take steps to avoid it in the future, if possible. But my view of the situation is that there should be a completely different criteria. I think that legal aid needs to really address that issue. On the other side of the scale, on the financial part, I mean, I had a lady that, without discussing details, she was, I think, $35 or $40 over that threshold, charged with very serious offenses where she was looking at up to 5 years in jail on a first offense, and she was refused. Now, there is a process, as you know, to try and get the courts to appoint lawyers. Generally speaking, that's a dirt road that gets really narrow and there's a cliff at the end. It doesn't really help you to start what's called a Robotham application, where you've been refused legal aid and then you go to the courts and ask a judge to appoint counsel for you. Those applications generally are fiercely opposed by, guess who? The prosecutors on behalf of the Attorney General and, of course, the Government of Canada. But I've taken those Robotham applications all the way to the Court of Appeal, and at different levels they've said, well, she can afford a lawyer, and the other ones say, well, I think she's smart enough to handle this case that's going to result in a 5-year penalty, or sentence. So I really think that there has to be more attention paid to the criteria for qualifying, I hope that our clinic can fill some of those gaps. When I was a young lawyer, starting off with my principal, one of my jobs was to make sure that we got money or retainers, and they were always criminal clients. And I think in those days there wasn't quite the culture, and this is the other viewpoint that I was telling you about earlier. I think that sometimes there can be a culture of legal aid where people expect to get legal aid.
Right.
And, you know, for example, you see somebody whose child is charged with a juvenile offense. Well, every juvenile gets legal aid, whether you live in the uplands or anywhere else in this city. And people take advantage of that. And I think that the system should, I think lawyers have to change that perception that, first of all, you don't always get legal aid, and you should pay for a lawyer. If you can't afford it right now, maybe your spouse or your father, your mother can help out. And we're not talking about a lot of money here. Most of the lawyers associated with that clinic are quoting fees that are slightly above what they would get on legal aid.
Well, how much is that?
Well, I think the general rate is roughly around $100 an hour for legal aid, and they operate on a block tariff, so you don't necessarily get paid for everything that you do for your client. You
Right.
don't get paid for adjournments, you don't get paid for phone calls, you don't get paid for meeting with people, unless it happens to be once out at Wilkinson Road.
Mm-hmm.
In my view, I think that there has to be a canvassing of issues. What I hope happens, what I really do hope happens, is that lawyers who do criminal work are given some authority to take legal aid applications and start screening people right in their offices.
Mm-hmm.
We're being asked by legal aid to rat out our clients if we find out that they're making more than $1,425, and I don't know really how many lawyers do that. You know, do you get a legal aid referral, and then when you find out your client's back at work, do you phone up legal aid and say cancel the certificate or cancel the referral? So I think that issue can be dealt with by lawyers taking the original intake, asking those questions that legal aid doesn't ask right now. Mm-hmm. Can somebody else help out? They never ask those questions. It's always your financial circumstances.
So where else in the city can someone go if they need to get access to justice?
Well, I think that the clinic model is a good one in various forms. As you know, you run a clinic yourself, and it's basically a public service. And yes, you do get clients from it, and it's expected, but the rewards are great. As you know, you've done a lot of that work yourself, and maybe not as high profile, or you're not right across from the courthouse, but they can certainly find you. And I think that that's where people need to go to get initial advice. Mm-hmm. This isn't the only place in Victoria where you can get that. A lot of lawyers will give half-hour consultations as well. Mm-hmm. Just ask.
So what about the law center operated by the University of Victoria?
We see there's, when you appear in court, you're given something called a timeline date, which
Right.
means that you must do something with respect to your charges. You either plead guilty or not guilty, you fix a trial date, and you're given an outside time in which to do that. Mm-hmm. If you don't do that, then you have to appear in front of a judge. First appearance court in this city is dealt with by justices of the peace. They can't take a plea, they don't sentence anybody, they're more of an administration. And they're a valuable service because they tend to unburden judges from that function. So if, for example, a date is given and somebody keeps coming back, they've been applying to legal aid, they've been turned down, they're appealing those decisions, or they've tried to come up with money for a lawyer and haven't been able to do so, they keep adjourning things until they hit that timeline date. Now, as part of the process, I think that the justices of the peace have got a form letter on the back of which states, look, if you really need help, go to the law center. That's good. I mean, I did that. I think you probably did as a law student. You participated in that type of a clinic. But I think to rely on that as a default, you know, if unrepresented people should all go over to the law center, I think it's a mistake. I think it's a learning experience for people under the supervision of lawyers, but to tell people that's where you go, I think is a mistake. I think that you should be directed to counsel who are willing to give that consultation, to try and work out terms for payment, for example. Maybe you don't need a $5,000 retainer. Maybe your lawyer is prepared to take it on a monthly payment basis. So there are some real alternatives to the default position. I'm not saying anything bad about the law center. The problem in some cases is that because of the turnover, they are students. You may find yourself going through 2 or 3 students.
Right. Now, one question that I always ask everybody is if you could tell us about your most interesting case.
Well, that was an income tax case. It was a farmer in Alberta who came to me who had been charged with failing to file his income tax returns. And this was right around the time when the Constitution came out, the Charter of Rights, Freedoms. And so I decided I would run and challenge what I considered to be the most nefarious section of the Income Tax Act, or I did. And that was the self-assessing section, where you have to estimate what Canada Revenue Agency's assessment's going to be. Of course, that's the basis upon which you make quarterly payments. Mostly it relates to self-employed people. Well, I argued successfully in provincial court, and I got the guy off. Of course, the Crown appealed, understandably. I ended up in Court of Queen's Bench there and then lost there. But we appealed to the Court of Appeal, and I got a 2-to-1 split. The judges all said, well, yeah, it's a violation of your right of freedom of expression not to express an opinion. But it's justified in a free and democratic society. So you got to estimate your taxes, despite the penalties.
So we just have about 30 seconds left, and I'd just like to maybe have you tell the audience how they could find you at the clinic and when they could find you at the clinic.
Well, we're kind of overburdened at the present. We do try and keep regular office hours from about 8:30 until 4:30 and possibly even later till 5. We will have a sign on the door if we're in court and usually state when we're back. We're at 810 Courtney, 50 feet from the Courtney Street entrance to the courthouse.
Okay. Well, thank you for joining us with Island Justice. We've had Barclay Johnson from Victorian Legal Clinic, and thank you.
The proceeding was an independently produced community access program. The viewpoints expressed are those of the community access producer and do not reflect those of Shaw Cable Systems. The program is presented in response to CRTC policy guidelines regulating community programming.